Hi, my name is Mombi, and today I want us to go through succession. So there are two types of succession. There is testate and intestate. So today I want us to deal with intestate succession. Okay, to give a brief about testate. Testate is where a person dies having written a will. Intestate is where a person dies with no will. So today I want us to deal with intestate. So intestate is, like I said, is where a person dies without a will. That is number one. Or he had a will and he intended to die testate, but the will is invalidated. Or he revoked the will and died without having written another one. There are two types of intestate. There is total and partial. Total is where a person dies without a will. Partial is where there is a will, but there are some properties which have not been included in the will. So you see, it will pass through testate and intestate. The other one is there is a will, but part of it is invalidated. Or there is a will and the person revoked part of the will. Okay? Yes. So when you come to intestate, it only benefits people with direct blood link. It only benefits people with direct blood link apart from the spouse. Apart from the spouse. So if you want it to benefit other people, you have to write a will. But if the deceased, if you are a dependent and the deceased was maintaining you prior to his death, you can make an application under section 26 of the Law of Succession Act, where you can say that you are a dependent and the court will make a provision for you. Okay. The intestate succession, there are some properties that don't pass through intestate. Number one is joint properties that pass through survivorship. Number two, nomination of life policy. Number three, donatio mortis causa. Gifts made in contemplation of death. So those ones, they don't pass through intestate succession. Intestate succession, of course, it applies to both monogamous and polygamous. Monogamous, where a person had one wife. Polygamous, where he had several wives, 1, 2, or 3, or many. Okay. So, what are the rights of spouse? Right of spouse. So, of course, the intestate succession, it applies to legal marriages. When you are married, when you are married under either customary or statute. However, if you are judicially separated, you can also benefit if you are judicially separated. And if you are divorced, you can't benefit. If you are divorced, you can benefit. However, a former wife is according to section 29 is a dependent. So she can make an application under section 26 so that she can be provided for. Okay, so there is a situation where there is a spouse and children. So how are the properties supposed to pass? Where there is a spouse and children. So where there is a spouse and children, the spouse will be entitled to personal and household effects. These are furnitures, clothing, those movable things. Personal and household effects, absolutely. And a life interest. A life interest, not the other property. But a life interest will hold the same interest for the children. He doesn't acquire a life interest absolutely. He will hold the same, the other properties, land and all those interests for the children. That is where there is a spouse and children. Now there is a situation where there is a spouse and no children. Where there is a spouse and no children, the spouse will be entitled to personal and household effects, absolutely. Number two, the first 10 Kenya shillings, 10,000 of the net residue, or 20% of the net residue, whichever is greater, and a life interest of the remainder. That is what the spouse will be entitled to where there is no children. And if you remarry, of course, the provision, all of them will terminate, will determine. Okay? So, there's a situation where there is children and no spouse. Rights of children. If there are children and no spouse, the properties will devolve according to Section 38 of the Law of Succession Act. The properties will devolve equally among the children. Succession that Section 38 of the Law of Succession Act. The properties will devolve equally among the children. And there's a situation where there's a spouse and children. If the spouse gets a life interest and he or she remarries, that life interest will devolve to the children. That life interest will devolve to the children equally. Okay, there's a situation where they're adopted children. Adopted children can only inherit from their adoptive parent and not their natural parents. So if you're adopted, you can inherit from the parents who adopted you and not the ones who gave birth to you. Your adoptive parent and not your natural parents. There's a situation also where there's illegitimate children. These are children born out of wedlock to a woman who is not married. So illegitimate children are entitled to inherit from the deceased or from their father. Number one, the deceased of course must have recognized them, accepted them as his children, and or was providing for them, and he has assumed permanent responsibility over the children. So they are entitled to inherit. There is a case that states that like a child or children of an adulterous union is entitled to inherit as he is his father's progeny. He is his father's progeny. And he does not even require to prove that his mother was married to the father. No. There's another case that states that a child or children of an adulterous union, they are children for the purposes of succession, so they can inherit. Children who are born out of wedlock by a woman who is not married, they are children for the purposes of succession and they can inherit. Now we go to a situation where the spouse, maybe they dissolved their marriage and the wife is pregnant. If that child is born 280 days, within 280 days after dissolution, that child will be considered as the child of the deceased or the child of that person. If the child is born within 280 days after the dissolution of marriage, that child will be the child of the deceased. Unless you bring evidence to court that they did not have access to each other at that time. You have to bring evidence to show that they did not have access to each other at that time. Okay, now also we come to the grandchildren. Grandchildren are not entitled to inherit. However, they can inherit when their parents, they are not entitled to inherit from their grandparents. Grandchildren are not entitled to inherit from their grandparents. However, they can inherit from their grandparents when their parents have died. So they are entitled to inherit the parts their parent was supposed to inherit through the principle of representation. So their grandchildren can only inherit from their grandparents through the principle of representation when their parents have died, and they can only take the share of their parents, the share which their parents were entitled. Okay, those are the grandchildren. Now we can go to other relatives. Other relatives, they are not entitled to inherit. Actually, like the way I've said, the intestate succession benefit only people with direct bloodline. So when it comes to other relatives, they are not entitled to inherit. They can only inherit where a person did not have a wife, did not have children. So when there is a situation like that, who is supposed to inherit? Number one, the father. If there is no father, mother. If the mother is dead, brother and sisters. If there is no brother and sister, the children of brother and sister. If there is no children of brother and sister, half brother, half sister, and their children, they will inherit in equal share. If there is no that, we say that the person who will inherit is the one who is the nearest degree of consanguinity, nearest blood relation up to the 6th degree. Up to the 6th degree. Those are the people who are entitled to inherit If there is no one, there is no relative, there is no blood relation, then the properties of the deceased will go to the state. It will devolve to the state, bona vacantia. It will devolve to the state. Now, I want us to deal with polygamous marriage. This is where the person had several wives. In polygamous marriages, properties are divided according to the number of children. Properties are divided according to the number of children. So, each child is considered as a unit. So if you have 5 children, those are 5 units, plus the wife, 6 units. That is the first house. If first house had 10 children, those are 10 units, and the wife, those are 11 units. That house had 4 children, those are 4 units, and the wife, 5 units. So the properties will be divided according to the number of units. Yes. Okay. So I want us to go through now the process of applying for the grants. Number 1, make sure you have original death certificate, chief's letter, which will show the beneficiaries. Then there are forms that are required to be filled. There is P&A 80, that is for the petition for letters of administration. There is P&A 5, this is affidavit in support, which shows the asset and the liability and the beneficiaries. P&A 12, this is the affidavit for the proposed administrators. There is P&A 57, this is for the sureties and guarantors. P&A 11, this is for the affidavit for the guarantors. Then there is consent form 38, that is a consent. So with this document, you have to fill them and you sign where you are required to sign. Now, there are details that are very important and they must be in the application, in the petition. Number 1 is the name of the deceased, date and place of death of the deceased, the last known address of the deceased, where he or she used to reside. Then you have to include all the assets and liabilities. All the assets and the liabilities. Then the beneficiary, include all beneficiaries and their relationship to the deceased. If it is the wife, indicate wife, son, daughter. If they are minors, indicate minors. Okay? Yes. Then, now, when you have all these documents, when you come to proof of ownership, you are required to put all the assets of the deceased. If it is titles, if it has parcels of land, you conduct a search. Make sure you do a search. You can bring a copy of the share certificate, logbook, all those. But at least something to prove that the deceased is the owner of those properties. Okay, now we come to the process of filing. You go to court with these documents and all the proof of documents that prove ownership, original death certificate, chief's letter. Go to court. Of course, you go to the court of competent jurisdiction, then you file. When you file, of course, you pay the court fees and you pay the Kenya Gazette. So when you come to Kenya Gazette, is that Kenya Gazette, the notice will be advertised for 30 days. It will be advertised for 30 days. This is to ensure that anyone who wants to make an objection, or who wants to object to the making of grant, he or she can object. But if after 30 days there is no one who is objecting, then you'll be given the grant. Okay? After you are given the grant, now you can wait for 6 months so that the grant can be confirmed. The grant can be confirmed. You know, there are situations where there are urgent matters where you need money, maybe for school fees, medical attention. You can make an application so that the grant can be confirmed before the lapse of 6 months. You can make an application in court. Okay. So after the 6 months, now you make another application called summons for confirmation of grant. Summons for confirmation of grant, where it will state the beneficiaries and the assets and how you want the assets to be distributed. This summons for confirmation of grant, this is where they state how the assets will be distributed. So this beneficiary will get this land, this one will get this. Now you agree. There you can agree on how the properties of the deceased will be distributed. And you have to go to court. All of you go to court and you say whether you are agreeable to the mode of distribution. If you are not, if you don't agree to the mode of distribution, you can file an affidavit of protest. where you are saying that this mode of distribution is not fair. So you propose your own mode of distribution. Then of course you have to go for hearing, and the court will hear you, and the court will make a ruling. Now after everything, after the contentious matter are over, now you'll be given a confirmed grant. Now with the grant and the confirmed grant, now you can be able to change the properties of the deceased from the deceased name to the administrators, then to the beneficiaries. Okay? Yes. Okay. There are situations where, like, maybe you have an interest in the estate of the deceased. Number one, you can file a caveat, so that wherever they are making the grant is being made, the grant is being confirmed, you will be notified. So you can file a caveat, so that every time there is something going on with that case, you'll be notified. You file it in court. Number two, there's a situation where there's some beneficiary they refuse to sign. There's some beneficiary who refuse to sign. You can cite them. So you can file something we call citation. You can file citation. You cite them and so that they can come to court and say why they are refusing to sign. Or situation where before even you file this process of the whole process of grant, before even you file, there's a situation where there are people with priority rights who are supposed to go and file and get the grant. But now those ones, they are not interested, and they are not even filing, or they are not even filing to get the grant. So you can cite them. You who have inferior rights, you can cite them and request them to come to court to show why they are not filing succession. Okay? Yes. So that is called citation. You cite them. Yes, you cite them. Then there is caveat. Okay. So I think we have come to an end for intestate succession. Yes.